share capital, share means a share in the share capital of a company. Share capital of a company limited by shares can be equity share capital with voting rights or with the differential rights as to dividend, voting or otherwise, or it can be preference share capital. The Act defines equity through preference share capital. It says preference share capital means that part of issued share capital which carries a preferential right for dividend as a fixed amount or at a fixed rate, and also preference in respect of repayment of capital. Premium may or may not have a preference, and these things are stated in memorandum or articles. Equity share capital is indirectly defined as a share capital which is not preference share capital. Voting rights as per section 47. A member holding equity shares has a right to vote on every resolution placed before the meeting, and his voting right on a poll shall be in proportion to his share in the paid up equity of the company. Section 47. Voting rights of a preference shareholder. He can vote on a resolution that affects his rights, and he can also vote on a resolution for winding up of the company or a resolution for repayment or reduction of equity or preference share capital. His voting right on a poll shall be in proportion to his share in the paid up preference share capital of the company. When dividend on preference shares is not paid for 2 years, it gives them a special right. They can vote on all resolutions placed before the company, and the proportion of voting rights between equity and preference shareholders will be the ratio of paid up amount in respect of the two categories. Rights of a class of holders can be varied when 3/4 of their group agree to it, or when they pass a special resolution in a class meeting, provided there should be an enabling provision in the memorandum or article, and the terms of issue of such shares should not prohibit the variation. Where there are holders having 10% of issued shares of a class who didn't vote in favor of the resolution, they have a right to approach a tribunal for a revision of the decision on variation. Tribunal's decision shall be binding and final, and the company is bound to file it with the registrar within 30 days. When securities are issued at a premium, the premium is credited to securities premium account. The securities premium account may be applied for specific purposes, 5 in number, towards issue of fully paid bonus shares, in writing of preliminary expenses, for purchase of its own shares under section 68, or for writing of expenses, commission or discount on issue of shares or debentures, or in providing for premium payable on redemption of preference shares or debentures. Where it is applied on any other purpose than the 5 above, the provisions relating to reduction of share capital shall be attracted. Except for issue of sweat equity shares under section 54, a company shall not issue shares at a discount. Any share issued by a company at a discount shall be void, and the company is liable to refund all monies received with interest of 12% per annum from the date of such issue. A company may issue shares at a discount to its creditors only when its debt is converted into shares in pursuance to a statutory resolution plan or debt restructuring scheme under regulations of RBI. Sweat equity is normally issued out of a class of shares already issued, subject to conditions. It has to be authorized by a special resolution, and the resolution specifies the number of shares, current market price, consideration, and the class or classes of directors or employees to whom they are required to be issued. And where the equity shares are listed, the sweat equity will be issued in accordance with SEBI guidelines. Sweat equity shares will rank pari passu with other equity holders as regards rights, limitations and restrictions. They are issued by a company to its directors or employees at a discount or for consideration other than cash in return for know-how, intellectual property rights or value additions. Employee means a permanent employee working in India or outside, and a director can be whole-time or non-whole-time and includes director of a subsidiary or a holding company. The explanatory statement is required to include details regarding justification for the issue, class of shares, total shares, and the class of directors or employees, their names and details, principal terms, consideration, diluted earning per share, etc. The sweat equity shares to be issued at a price determined by a registered valuer. A summary of the valuation report shall be sent to shareholders along with the notice. The special resolution, as passed, will be valid for allotment for a period of 12 months from the date of passing. Annually, the amount of sweat equity shares issued cannot exceed higher of 15% of existing paid up capital or value of rupees 5 crore. Overall ceiling is it cannot exceed 25% of the paid up capital at any time, and the shares are locked in and non-transferable for a period of 3 years from allotment, and the director's report for the year will make a detailed and comprehensive disclosure on various aspects of the scheme. A company can increase its subscribed capital by way of issuing further shares to the existing shareholders in the ratio of the paid up capital by way of a letter of offer, which specifies the number of shares offered, and it gives a timeline of 15 to 30 days to accept and act on the offer, within which if the offer is not accepted, it shall be deemed to be declined. The offer also is deemed to include a right to renounce in favor of any person. After the expiry of the time frame, Board of Directors at their discretion may dispose of the shares not taken up by the shareholders. Further issue of shares to other than existing shareholders is permitted with the help of a special resolution in 3 situations. 1, under a scheme of employee stock option. 2nd, under a prospectus based on value determined by a valuation report, or increase of subscribed capital by way of the debentures and loans which were raised in the past under a special resolution passed which authorized their conversion into equity. Regarding employee stock option scheme, a listed company required to comply with SEBI employee stock option scheme guidelines, under which an employee means a permanent employee of the company working in India or outside. He may also include a director of a company, full-time director or not, but excluding an independent director. An employee of a subsidiary or of a holding company is also included, but the definition doesn't include an employee who is a promoter or a person belonging to promoter group, or a director who directly or indirectly holds more than 10% of the equity shares of the company. The explanatory statement to the shareholders' resolution shall cover extensively the number of stock options, classes of employees, the appraisal process for eligibility, requirements of vesting and the period of vesting, exercise price, exercise period, process of exercise, lock-in period, and conditions under which option vested in employees may lapse, along with the time period to exercise the vested options on termination or resignation of employee. Other unique features of the scheme: the minimum period between grant of option and vesting of option will be 1 year. Freedom to specify lock-in is with the company. Employees will not have a right to receive dividend or vote till the shares are issued. In the event of death, options granted shall vest in the legal heirs. Options granted cannot be pledged, hypothecated or mortgaged, and in the event of resignation or termination, options not vested shall expire, and there will be extensive disclosure in the director's report for the year on the details of the employee stock option scheme. When a company is eligible under foreign exchange management rules, it can issue depository receipts. But there should be a board resolution to that effect, which should have a prior approval of shareholders by a special resolution. Any resolution passed under section 62 will suffice, and the depository receipts are issued by an overseas depository bank appointed by the company, and the underlying shares shall be kept in the country in the custody of a domestic custodian bank. The company is under an obligation to ensure compliance with the guidelines of RBI before and after the issue. It appoints a merchant banker to oversee the compliances. The compliance report from the merchant banker presented to the board at its meeting held immediately after closure of the issue. The depository receipts may be issued against new shares or against shares already held by shareholders. The underlying shares shall be allotted in the name of the Overseas Depository Bank. The holder of a GDR can convert it into a share and then become a member of the company. Until such time, voting rights in respect of GDR are exercised by the Overseas Depository. The proceeds of the issue shall be remitted to a bank account in India, or it can be deposited in an Indian bank operating abroad. The provisions as to prospectus are not applicable in respect of offer document of GDR. Equity with differential rights issued after fulfilling certain requirements. There should be an enabling provision in the articles. Shareholder consent through an ordinary resolution required. When the company is listed, it should be through postal ballot. And the voting power with the differential rights should not exceed 74%, and the company should have a consistent track record of distributable profits for the last 3 years. The company should not have defaulted in filing financial statements for 3 financial years immediately preceding. There should be no subsisting default in respect of payment of dividend, repayment of mature deposit, redemption of preference or debentures that have become due, payment of interest on deposits or debentures, or payment of dividend. The company should not have defaulted in payment of dividend on preference shares or term loan or interest payable on the term loan or deposits. And there should be no dues as regards statutory payments and no default in crediting the amount in Investor Education and Protection Fund. And the company should not have been penalized for the last 3 years for any offence on acts like RBI Act, SEBI Act, SCRA, FEMA, or any other special act. It is required that the explanatory statement going with the resolution should specify the scale or proportion of varying voting rights, effect on control and the diluted earning per share, and the shareholding pattern before and after the issue. Board's report for the year should also disclose all the relevant details. The company doesn't have a right to convert existing equity share capital with voting rights into equity share capital carrying differential voting rights and vice versa, and all other rights remain the same between equity and equity with differential rights, be it bonus shares, rights shares, or similar things. Subject to certain conditions, bonus shares can be issued under section 63 out of free reserves, securities premium account, or capital redemption reserve account. The conditions are there should be enabling provision in the articles, and it has been authorized in a general meeting based on a proposal by the board, and the company has not defaulted in payment of interest or principal in respect of fixed deposits or debt securities, and also the company has not defaulted in the payment of statutory dues like provident fund, gratuity and bonus, and before issue of bonus shares the company shall have converted all its outstanding partly paid up shares into fully paid up shares. No issue of bonus shares shall be made by capitalizing reserves created by the revaluation of assets. The process of buyback is subject to certain restrictions. A company can purchase its own shares or securities from out of free reserves, securities premium account, or proceeds from issue. The buyback has to be authorized by its articles. A special resolution is required to be passed authorizing the buyback. However, if the buyback is 10% or less of the paid up capital and free reserves, just a board resolution is sufficient, and the maximum limit on buyback anytime is 25% or less of the aggregate paid up capital and free reserves. Secured and unsecured debts after buyback should not be more than twice the paid up capital and free reserves. The shares covered under buyback need to be fully paid up. If listed, the buyback has to be in accordance with SEBI regulations. A declaration of solvency signed by at least 2 directors to be filed with SEBI stating the company will not be rendered insolvent within 1 year from the date of declaration, and every buyback has to be completed within a year of the special resolution or board resolution. Buyback may be effected from existing shareholders or from the open market. And once completed, the company shall extinguish the securities within 7 days of the last day of buyback, and from the closure of one buyback to the commencement of another buyback, there should be a lapse of a minimum of 1 year. A return containing the particulars of the buyback shall be filed within 30 days of completion with the registrar. No company shall purchase its own shares if it has defaulted in repayment of deposits, interest payment, redemption of debentures or preference shares, payment of dividend to any shareholder, or repayment of any term loan or interest thereon. No company shall purchase its own securities where it has not complied with the provisions of Section 92 for annual return, Section 123 for dividend declaration, Section 127 for dividend payment, and Section 129 for financial statements. Alteration under Section 61 permitted if authorized by articles by altering the memorandum of association in a general meeting. It involves increasing authorized capital, consolidating and dividing the shares into shares of a larger amount, subdividing the shares into shares of a smaller amount, or cancelling shares which have not been taken up and diminishing the amount of share capital by the amount of shares so cancelled. For every alteration, notice to be given to registrar, and alteration includes mere cancellation but no reduction of capital. It needs approval from tribunal wherever it adversely affects voting and other rights of shareholders. Reduction of capital under Section 66 is a two-step process: one, special resolution, and confirmation by the tribunal. A company can extinguish or reduce liability in respect of share capital not paid up, or it can cancel paid up share capital to the extent it is lost or unrepresented by available assets, or it can pay off any paid up share capital which is in excess of the requirements of the company. Once this is done, it can alter its memorandum by reducing the amount of share capital and the relevant shares. However, the tribunal may grant confirmation only if it is satisfied that the debt or claim of every creditor of the company has been secured and protected. The reduction has certain strict steps to be followed. No reduction shall be made if the company is in arrears in repayment of deposits or interest payable on them. The company has to be in conformity with accounting standards and other provisions of the Act, and a certificate from the auditor is to be filed with the registrar and the tribunal. The company shall deliver a copy of the order of the tribunal to the registrar within 30 days of its receipt, and the ROC shall issue a certificate thereupon. Where the name of any creditor was not entered on the list of creditors prior to approval of the reduction, every member on the date of registration of the order by ROC shall be liable to contribute.